Well, thank you so much, and thanks for being so patient with being with us today. We know it takes a lot of time, but your townships are in the midst of making decisions that will affect you for a generation or perhaps more. So, we'll try and share some things that are very valuable with you. First, we heard the issues of what happens for Mr. Hartke when zoning doesn't do a good job. And so Mr. James then brought some acoustic information to explain the mechanism behind some of these complaints. I'm now here to give a recommendation and some ideas on zoning policies that can put in place that will protect the private property rights of all the people in your township, as well as reduce or eliminate these acoustic complaints that we hear in various communities. So who is this guy? Well, I got a degree from the University of Michigan. Of course, so does the Unabomber. I was the vice chairman of the Riga Township Planning Commission for 6 years. I also worked on ag land preservation, and I helped draft a wind energy ordinance that was later added to a list of model wind energy ordinances by the state of Michigan. Some of these are quite permissive, some of them are quite restrictive. By the way, I'm not a lawyer, but I do watch Law and Order, and I, like Mr. Glazer, as far as I know, am not licensed in the state of Michigan. He may be admitted to the Western federal courts. State law is what drives land use policy, so keep that in mind. I'm sure he'll correct me if I'm wrong. Nothing I say today should be construed as offering legal counsel. Developing wind energy ordinances that can withstand legal scrutiny is a specialty. We learned this in my township early on. If you don't have a strong municipal attorney, the wind industry's attorneys will push your guys into a corner, and they will start making suggestions that they're going to bring suit against you if you don't bend to their wishes. Make sure you have strong legal counsel on your side so that you can exercise your appropriate role of protecting the health, safety, and welfare of your citizens. I understand for those of you who are planning commissioners or trustees exactly what it's like, because the wind energy industry brings a proposal to your community, and if your township is like mine, the most radical thing you've ever had to create land use regulations for was maybe a mobile home park or something like that. But they show up and say, look, we're going to force you to make this a yes or no decision. Give us our ordinance that we want, that we had brought to you either by Spicer, or in my case, they brought ordinances from Oliver Township and Huron County, and so this is what everybody does, and look, it matches the state guidelines. Well, what do you know? Those ordinances were all generated by largely the same group of people. What do you know? They were 1,000-foot setback and 55 decibels. The bottom line is they're putting you in a tough position to make a decision about every piece of private property in your entire township as a 5-member board. I don't think it has to work that way, and I'd like to show you why. If you write reasonable wind energy regulations driven by the principles of consent and compensation, which I'll explain to you, then your landowners can make the decisions for themselves about what the value is for their amenity of home, etc. Now, the Michigan experience. I'm going to talk about a few things that are not directly wind energy zoning policy directly, but we hear so many claims by the wind promoters about all the benefits of wind that have nothing to do with health, safety, and welfare that I thought I should address a couple of them here. Initially, the state recommended these very permissive guidelines. That came from John Sarver's group, the Wind Working Group. Jennifer Granholm decided they were going to really make this the Saudi Arabia of wind, like approximately 30 other states have called themselves. So they started with these very permissive limits. Well, over time, we found out that's been very problematic. Garden Township, litigation, referenda, recall attempts, all kinds of disputes here now. We got abandoned homes in Misaki. We got same kind of issues in Ludington. The turbine that fell down on the front of the room here, and it looks like if you read the newspaper, they fall down more often than you'd think. That fellow also abandoned his house and moved several miles away from the turbines to get away from the impacts. This is happening. These are real people. This is really happening. And I'm appalled that Peter Goldberg from Tech Environmental would ever suggest that we write planning ordinances that presume a 5 to 10% loss rate. I mean, if you designed a bridge that you said 90% of the people will be able to cross it safely on any given day, you would fire that engineer in a heartbeat. These wind regulations have become a big, big problem. Here's 14 turbines in the Garden Peninsula. Heritage had built those turbines there. They're also building some in the Thumb. 73 people have signed a petition saying, please stop the turbines. Mr. Legina has recognized that the turbines are noisy and annoying, and they're in the process of adopting a police power ordinance regulations, a nuisance noise ordinance regulation that will actually retroactively cause them to quiet those turbines at night. If your zoning gets written and the turbines go in and you continue to have problems, While they're grandfathered in under that zoning ordinance, you still have the power, according to the attorneys I've consulted with, to write nuisance noise ordinance regulations like you do for any other nuisance noise. And you can retroactively regulate the sound coming out of those devices like any other activity on land. So it's not the end of the world if the turbines go in and you have issues. You can simply write strong nuisance noise language that will correct them after the fact. That is what's happening in the Garden Peninsula. The latest publication from the state of Michigan references, they don't endorse, but they reference a 1.25 mile setbacks and noise limits below 40 dBA. Again, the state just gave a recommendation before. My point is to show the trend, where they went from 55 to 1,000. They're now actually allowing documents like this to see the light of day. That's a tremendous change for the state. Now, a lot of times we'll hear that we got to build this stuff for the sake of the environment. We've spent over $3 billion on wind turbines in the state of Michigan so far. The most we could have reduced coal emissions with that would be by about 6%. Had we built combined cycle gas turbines plant, we could have reduced those emissions by 50% for the same amount of money. MISO, you've heard about the Clean Power Plan, and you've heard recently that the Supreme Court put an injunction or stayed that enforcement of that. Of course, Justice Scalia passed away. We're not sure where that's heading. But MISO, our grid operator, they did analysis of the Clean Power Plan for all the stakeholder states. And they looked at all the steps of the building blocks. And it turns out wind energy does reduce CO2, no question, but at a price of $237 a ton. If you just built combined cycle gas turbine plants like Invenergy builds, and they build wonderful ones. The guy that runs Invenergy is a big believer in thermal power generation. You could reduce CO2 for about $35 a ton. So in other words, for every ton you reduce with wind, you could have reduced 8 tons. And we know that's true. Here's one of Invenergy's plants. They said every megawatt of power generated by an Invenergy natural gas fuel plant produces nearly 45% less carbon dioxide than would a typical coal-fired power plant of similar scale. Had we been building gas all along instead of wind, we would have replaced half of our dirtiest coal plants already. That's beyond dispute. Well, that's right. You wouldn't have to build the thumb loop and things like that. Now, let's look at land use intensity. Here's the Fermi 2 nuclear plant in Newport. I got a friend that works there, actually. They make 1,100 megawatts of baseload power, emissions-free. Could you replace that with wind turbines? Sure. You put 2 Vestas V100s in every square mile, from Toledo to Detroit to Ann Arbor, with presuming a 30% capacity factor. And that would replace the annualized generation potential from that nuclear power plant. But you would still have to build 1,100 megawatts of Invenergy's finest gas plants, because in July and August, as you know, by driving through the thumb, there's too many hours of the day that they don't turn at all. Considered this way, the 36 square miles of turbines they're proposing here, 50 stories tall, you can produce that same amount of energy in a semi-trailer mounted gas turbine plant that would fit inside your average dairy barn. Now finally, we hear a lot of talk about why Michigan's a very important and competitive place to produce wind energy. It just is not. As you can see here, our very best wind is around the tip of the thumb, and then in this interior region, not quite as good. Our very best wind is the worst in Iowa. Every wind turbine that gets built in Michigan rather than Iowa would produce roughly twice as much electricity in Iowa. That's why the power purchase agreement prices for prairie wind consistently remain far cheaper than the power purchase agreement prices for wind in Michigan, about 2 to 1. Wind is not a competitive energy product for the state of Michigan. The state recognizes that, the legislators recognize that, Valerie Grader recognizes that, the governor recognizes that. So, now we're going to get back to the strictly zoning questions. How do we evaluate any project? Well, we look at the total cost of ownership. To know whether or not something's worth participating in as a community or as an individual, we need to do a cost-benefit analysis. That's easy enough with a car. We can do that all day long because we've owned a lot of cars over our lifetime. We can ask all these basic questions about what kinds of things we prefer in our cars because they're a very familiar product. But when a wind guy shows up and he says, I want to build some 100-meter class Vestas V100s, and we now have to ask some questions about unfamiliar things. Now, you guys are more familiar because you don't have to drive very far north to see them. In 2008, I had to drive to Ubly to find turbines, because they were only in Ubly, Mackinac City, and Missaukee County at the time. Now they're very easy to find. You guys have a lot of experience with them that I didn't have in 2008 and 2009. So we know how tall they are. They're about the size of the Mackinac Bridge. In fact, there's 660 footers now being proposed in Bellevue, Ohio, according to the FAA website. So that's the next order of magnitude that's coming around the bend. And of course, here's the one that fell to the ground, 1,139 feet. Curiously, the acoustician that said that that would cause no harm at 1139 in Mason County said that my wind that they wanted 1320 in my township, same acoustician, because that was safe, and the proposal for 1,000-foot setbacks by UV wind was unsafe. Curiously, that same acoustician had testified a few years earlier in Vermont that those turbines out there were going to cause health impacts up to 1.25 miles. So let's say sometimes the wind industry's experts can be very flexible. We got a saying out here in the country, right? He that pays the fiddler gets to pick the tune. You need to be careful. These folks now have left that house. They sold it for 30% below the appraised value. And they had to put all kinds of easements on the deed saying that the people are aware, because there was litigation involved, with all the impacts of buying that house. So, you're a planning commission member and you're trying to figure out how to best regulate these things to protect your community. We know that the Michigan Zoning Enabling Act says that the goal of our ordinance is to protect the health, safety, and welfare. And if the proposed activity cannot be performed safely, then we should not permit it. We should regulate in a way to make sure that things are safe. The developer's primary commitment is to bottom line, and their recommendations are designed to maximize return on investment. We know that because they're pigeonholed in the same setback distance no matter how large the turbines become. When the turbines are 1,000 feet tall, they're still going to have to tell you that we need a 1,300 or 1,400 foot setback, even though they're twice the size, because if you get past 1,500 feet to a house, they have to lease too much property and it becomes difficult to build. They were at 1,000 to 1,320 with 400-foot turbines, 500-foot turbines. They'll be there at 600 and 700-foot turbines because their recommendations are designed to maximize the return on investment. They don't show a rational relationship between health, safety, and welfare. As the bigger they get, the impacts obviously grow. So, what are the limits to zoning? How far can you go? Zoning regulations must have a rational relationship to protecting health, safety, and welfare. Again, I'm not an attorney. Consult an appropriate attorney for these decisions in your own township, but I am going to give you some land use policy suggestions. Those ordinances can't be arbitrary or capricious. You can't write a zoning district that says only Presbyterians live here. That would be too far, even if you don't like Presbyterians. If a zoning regulation meets those criteria, it's almost unassailable in court. Reasonable zoning is strong. When my attorney in my township, when we made some recommendations, the wind developers were apoplectic about it. And I said to our attorney, these guys don't seem to like what we're recommending. And the attorney says, who cares what they like? And that's the appropriate attitude. The developer's wishes are not what you have to regulate around. You simply have to ask the question, what would you like your community to look like? What do you think is safe? Wind developers, as you're seeing with the flyers stuck under the windshields and the flyers passed door to door and the hats handed out at the intersections, will offer all kinds of crafty and superficially enticing arguments and promises. But as we have heard, the statements made by their representatives in the room don't mean anything once the ordinance is in effect, because now you're responsible. Your township's now responsible, and they want to transfer the liability for the safety of that project to your community. So, are developers' profits more important than health, safety, and welfare? Are promised increases in tax revenue more important than health, safety, and welfare? Are claims of private property rights more important than health, safety, and welfare? Are claims of green jobs or emissions reductions more important than health, safety, and welfare? No. Remember, it's health, safety, and welfare, not health, safety, or welfare that zoning commissioners are duty-bound to protect. Too often, health and safety are diminished in exchange for developers' promises of jobs or tax revenue welfare. But those promises are not contract. Just go to Huron County or talk to the Tuscola County commissioners about all the promises made by the wind developers to be good neighbors and to pay all the tax revenue necessary to your community so that you get the maximum amount of good. And now all those guys are in the tax tribunal in all kinds of complaints and disputes about we don't want to pay the higher tax rate. Keep in mind, a typical turbine costs them $4 million. Let's say 20 people in your township would rather not live next to turbines and your houses are worth $100,000 a piece. For the price of half of one turbine, they could offer buyouts to those people. For the half of one turbine. It's not even a blip on a pro forma. All kinds of impacts. We could talk about all kinds of things associated with regulating turbines, just like any other land use. I'm going to focus on only a few. Height limits. In general, communities are free to regulate the height of structures simply on the basis of appearance. For instance, I bet you have zoning ordinances that say your homes in your residential district can't be more than 30 feet tall or 2 stories. Is that because 4 or 5 story homes can't be constructed safely? No, it's because you decided we don't want to see anything taller than this in this district. That's standard. You probably got a 50 or 60 foot height limit in your ag district, and you probably exclude out leg elevators and grain bins for obvious reasons. Standard practice, no big deal. Wind turbines are no different than any other lawful use. You may restrict their size for the sake of appearance. Like, why do we regulate billboards? We didn't have to prove that that billboard was going to cause injuries to people's health to apply regulations to it. We just simply had to say, how big of a sign do we want to see? That's all we had to ask. You probably got regulations in some of your communities that say signs in front of a bank can't be bigger than 30 square feet. Is it because 40 square foot signs are going to make people ill? No, you're just saying that's all the more we want to see. You can simply enact a height limit to say, we don't want anything taller than this. The purpose of regulating signs, for instance, in Stark County, is to provide for a visually pleasant environment and minimize potentially unsafe conditions while also offering opportunities for public and private information and advertising. Why would you set a 100-foot height limit for wind turbines? Because you thought 150 was too big. And we know wind turbines have visual impacts. You know, it's common to say that you pull all these internet lies and so forth. And yes, you can find lies and misinformation about wind development on the internet, which is why I stay away from Invenergy's website, and NextEra's website, and the American Wind Energy Association website. But how about one of the vice presidents of Detroit Edison? He gave an interview on a podcast, and he said some interesting things. Certainly there are some pristine places in Michigan where you don't want to impact the viewshed. You take a situation like Leelanau County or the old Mission Peninsula here in our region. Whose backyard is that? Certainly there are areas where it just, well, it would be perfect economic sense and perfect placement for utility turbines. We probably don't want them as a region here. Steve Rawlings, DTE. Apparently when they built the turbines in Huron County, they didn't think it was pristine enough. So how tall is too tall? Just like any other land use, it's up to you. So, setbacks, who to trust? They'll pillory my friend Rick James on noise and acoustics and so forth. Why don't we go to the manufacturer of the turbines themselves? Now, the wind guys will dance all over around why they shouldn't have to honor these kinds of verbiage. But Vestas health and safety instruction makes it clear if a runaway operation should occur, the plant must be evacuated immediately by running upwind. And access to the surrounding area in a radius of at least 500 meters must be restricted, 1,640 feet. I don't know what it will be for the 660 footers. Nordex, same thing, 1,640 in case of fire. Here's a 390 footer in DeKalb, Illinois, one of NextEra's turbines. The debris field there was reported to me to be about 1,500 feet. It appears to me that they have some reasonable idea about why you need fairly large safety perimeters to protect people. Developers' wishes, despite, oh, yeah, go ahead, Ted.
Go back to the last slide. Did that turbine fall straight down like it was designed?
No, of course not. In an overspeed event, what happens is the rotor continues to flex back until it contacts the mast and explodes. I don't know what happened to the one in Siegel. They keep telling us it never happens. And so if you think it happens, you've believed another internet lie. Despite being on the front page of the paper. Despite published safety data like that on the earlier side, wind developers routinely demand turbine setback distance ranging from 1,000 to 1,400 feet from neighboring homes. Here's a phrase that I want you to remember. It's called trespass zoning. By demanding that the setback distances for wind turbines be measured from homes on adjacent properties rather than from the property line, which is typical for all other land use regulations, the wind developer is in essence asking the regulatory body to grant them trespass privileges on unleased property. We call this trespass zoning. What's that look like? Well, remember, they're recommending 1320, even though their particular manufacturer might say 1640. It's not to scale. I'll show you one to scale in a minute. In the event of a fire or an overspeed event here, and presuming the wind is coming from this direction, their operators would have to run more than 300 feet past your house to get to the safety perimeter. Now, nowhere in the ordinance did anyone propose that at least they knock on the door on the way by. Not to mention, how do they take care of the trespass element? Now, moving it back to the safety limit to the house, okay, you're now at least out of the imminent danger zone. But look at this. The rest of your property isn't. This is the argument right here. This is why they bring high-priced attorneys in. This is why they spend $160,000 on PR in 136 square mile township. They want this for free. They want your neighbor's property for free. This much I know, in rural communities, the high priority we place is on one attribute: neighborliness. Good neighbors don't demand their neighbor's property to be donated to their tenant. Their tenant. We've basically given future development rights for this property on the left to the neighbor's tenant for 40, 50, 60 years. Now they say, we don't really have an impact here. You want to bet? Let this guy sign a lease with a competing wind manufacturer and start to put a 500-foot turbine up to 500 feet from this one. They'll be in litigation in a heartbeat. In a heartbeat. The only reasonable way to zone for these things is that the setback limits would be established at the property line so everybody's future development rights are preserved. Here's an example of trespass zoning. This comes from Bridgehampton Township. These are the kind of submittals you see with their applications. I'm going to zoom in a little bit. The green parcels are identified on the map as being participating landowners. The gray parcels are unleased properties. The circle, the red one here, that I will try and hold my shaky hand on, is the 1,320-foot setback. Still 320 feet smaller than the larger turbine manufacturers I recommended. If you zoom in on that parcel in the center, you can see that roughly 50% of this unleased farmer's property is now basically in the control of your zoning ordinance and the neighboring farmer's tenant. His future development rights were surrendered to the neighbor's tenant. That's trespass zoning. Now you say, what about my right to do what I want on my property? Oliver Wendell Holmes summed it up well. The right to swing my fist ends where the other man's nose begins. My corollary is if my development project requires me to repeatedly punch you in the nose, I should first get your consent and then compensate you for your broken nose. But they want zoning ordinances that allows them to punch you in the nose all night long with no risk of penalty. The express goal of zoning regulations, by definition, is to separate conflicting land uses from each other. That's only common sense. Why did we create the zone in the first place? Ag here, residential here, industrial here, rail yards here, commercial here. To separate the various nuisance aspects of those land uses from each other. When you make the setbacks and noise limits from the home, you just legalized the unseparation of the conflicted part of that land use. It violates the basic premise of land use policy in the first place, to separate the conflict. You just granted them the right to trespass on the neighbor with the conflict. You've actually granted legal access to the neighboring property without consent or compensation. This is just fundamentally unjust. You don't have to be anti-wind to say there's something wrong with this. So what is the right setback distance? Well, I would say if you're regulating to protect families from fire or odor failure, maybe 1640, or convert it to a multiple of the turbine height, which will allow you to compensate as the turbines grow, measured at the property line would be eminently reasonable. How could anything be more reasonable than? If you're regulating setbacks to serve as a proxy for noise regulations, however, if you decided you're going to make the distance protect you from the noise rather than measurements of noise, and here's why you want to stay out of the measurement trap if you can. In Mason County, they've been trying to enforce their noise ordinance against Consumers Energy Lake Winds project. The county had the money to proceed. Your townships will not. It had been a multi-year legal battle with dueling experts, multiple payments to these guys, outrageous sums of money, went to the appeals court. They ultimately settled. It's going to be experts versus experts about LEQ, L90, L10, stuff that makes your average guy's eyes glaze over. Who are you going to send out to do that enforcement? Your building inspector? I mean, you can't even begin to take the measurements without writing a $10,000 or $15,000 check. So maybe you're just better off adopting a large setback and let that serve as your noise protection rather than the noise limits. And if you're using setbacks to protect property values, maybe a 2-mile setback would be reasonable, but maybe a height limit would be more defensible. So in my township, we picked a 4 times the height to non-participants' property line, but a 1/4 mile to participants' residence. Both these numbers could be reduced with a waiver. It's important, in my opinion, that the setback to non-participant be at the property line, we're essentially awarding an uncompensated nuisance and safety easement to the developer at the non-participant's expense. We should not forcibly donate each other's property to each other for the sake of their development project. In my mind, a 2-stage waiver is the key. By setting big setbacks to unparticipating property lines and small ones to the guys that want the turbines, the project can still go forward if they want to negotiate that setback, but at least your bargaining power has been restored to you. The zoning ordinances proposed by the wind developers working in the 8 townships around here right now have stripped all the small landowners of their bargaining power completely. They don't need your 2-acre parcel to proceed with the project if the zoning is approved. They've taken away your negotiating power. In my mind, that's fundamentally unfair. If they have to negotiate with all of you because of the setbacks, then each person can decide what the value is of the amenity of his or her home, rather than having your board decide for you. And the checkerboard fashion is interesting too. In our township, the wind guys kept telling us, we can't tell you where the turbines are going to go because your ordinance isn't complete. Until somebody discovered the FAA, they'd already recorded 120 turbine locations with great precision. So once those turbine locations were, and I haven't done that for your township, you may want to do it if there's turbine maps not available yet by the developer. Once that map was revealed, the farmers who'd been arguing about which developer to lease with and were patting themselves on the back with the thought that they're going to get a lot of turbines, suddenly saw that the farms they thought they were going to get revenue from had no turbines plotted on them whatsoever. Suddenly, the pro-wind farmers and large landowners weren't so happy anymore because the developers had sold them a bill of goods. And we've had multiple farmers sit in the room together with the leasing agents, and the wind guy would say, look, I only want your farm or your farm, I don't need both. So their intent is to lease as little property as possible to make the project go forward for economic reasons. They're not really interested in leasing your entire township. So how loud is too loud, and who do you believe? Well, Rick did a lot more on this than I can, and he has the proper credentials. Though land use people are expected to make decisions on all kinds of things for which they don't possess the credentials, that's the nature of the beast. Well, Rick's already gone through this stuff. I'm not going to beat it. Rick gave me these slides a few years ago. But let's look at a couple experts that I think you find it hard to criticize. The American Wind Energy Association had an expert named Dr. Robert McCunney. And he wrote a paper that said, Wind Turbine and Health Effects, an expert panel review that said 45 dBA LEQ, which is an hourly average, would not cause adverse health effects. However, Dr. McCunney participated in a seminar wherein he made it very clear that if it was his home in the vicinity of a wind farm, he would want the noise levels to be kept below 35 decibels, something along those lines, maybe 40 is measured outside his home. And the reference for that brief is right there. Talk about a NIMBY. How about the Hesslers? The Hesslers work here in Huron County. I've run into them down in Clinton County. They do a lot of work for the wind industry. They are sharp acousticians, no question about it. But the state of Minnesota hired them, and they made this recommendation. Based on the observed reaction to a typical project, it would be advisable for any new project to attempt to maintain a mean sound level of 40 dB or less outside all residences as an ideal design goal, not 55. It is important to note that a project level of 40 dBA does not mean the project would be inaudible or completely insignificant, only that its noise would generally be low enough that would probably not be considered objectionable by the vast majority of neighbors. We're back to Peter Goldberg's rule. Is a 10% loss rate acceptable to you? Rob Rand, an acoustician who's looked at a lot of the problematic turbines on the East Coast, he wrote a letter to my township, and he says, our experience in New England is that 45 dBA and 1,300 feet are associated with widespread complaints, appeals to stop the noise, and legal action. We don't see that everywhere. Some of it's dependent on how many of those good neighbor agreements are signed. Because once you sign the good neighbor agreement, it's very, very difficult for you to make complaints anymore. But we do see these kinds of responses around the Midwest. Vestas also talks about low frequency noise. Vestas also recommends that, I shouldn't say low frequency, supplement relative noise limits, in other words, ambient plus, with a low absolute maximum areas of very low background noise. which ensures minimal noise disturbance for turbine neighbors in these quiet rural places like you have here. What that means is that you want a real fixed limit, like a speed limit on the expressway. If the speed limit on the expressway is 70 miles an hour and you get pulled over doing 83, you can't go back to the cop and say, well, look, if you average my speed over the last 60 minutes, I actually was only at 68 and a half. I'm sure the fellow in the back of the room would agree that's not an argument that's going to pass muster. And not only that, it's incredibly difficult to enforce because you got to measure these averages and so forth. An LMAX means it's a fixed limit, 71 and a 70, and it's actionable. I'm going to skip this slide. We went with a 40 decibel nighttime noise limit at non-participating property lines, only at night. It only makes sense. I think it's defensible in court because at night when you try to sleep. In the daytime, it was a little higher. We also added 55 dBc, low frequency noise limit. We consider these to be a reasonable compromise with the developer's desire and concerns for health, safety, and welfare. Shadow flicker, 30 hours a year is what they often recommend. What they've done over in Mason County, Consumers Energy is finally using the sensor system. They're stopping the turbines during certain times of the day when the flicker occurs. You don't have flicker now. I'm not sure why you'd ask for it. Detroit Edison has been pretty responsible about stopping turbines and reprogramming them to minimize some of the flicker events. The bottom line is the wind guys say as technology increases, the impacts will diminish. Good, the technology exists now for them to generate zero shadow flicker on your home. So let them follow through with their latest in technology and go for zero shadow flicker. Now, decommissioning matters. They say the scrap value of the turbines is enough to pay for them to be removed. I heard a guy, Stephen Smiley, used to work with Rich Vanderveen, Mackinac Power. In Ogama County, he said that you don't need decommissioning money. You loosen the bolts and stack dynamite at the base and you drop them like a tree. And then they cut it up for scrap. Now, you go look in Chandler Township and tell me you're going to drop those things with dynamite. If the scrap value was adequate to pay for the removal, these wouldn't still be standing in Hawaii. Okay. I recommend a decommissioning bond requirement with a value determined by an independent third party selected by the municipality and paid for by the wind developer. Developer often recommends a financial guarantee rather than a bond. And I'll tell you why that's not recommended. The turbines in Ubley were originally owned by Noble, then John Deere, then Exelon, and now I see Continental out there. The people you're negotiating with today are not likely to be there 10 years from now. Ask the people negotiating with Geronimo and the Thumb. Turns out Geronimo says they don't even ever build any projects. They basically work as land advance people, and then they flip the project to somebody else. They just want a township that's negotiable on the open market, that's marketable, and they want the zoning, they want the transmission, they want a buyer for the power, and they can peddle the project. We found that out in my adjoining township. Some signed with UV, some signed with Exelon. The farmers patted themselves on the back. I picked the right one. No, I picked the right one. These guys are jerks. No, these guys are great. Until they got zoned out of one township and Exelon bought all the other guys' leases and suddenly they were in bed with the guy they never wanted to do business with. That happens all the time. So the people you're negotiating your wind ordinance with are likely not to be here 30 years from now. NextEra published this thing online. You can see that most of their money in the first 10 years is from the tax issues. In the outlying years, we're really not sure what's going to happen as the production tax credit expires. Some of these things were done on a Minnesota flip deal where they go back to the original developer when Billy Bob's Wind owns it instead of NextEra. It's not really certain where the money's going to come from to repower those things 15 years out. We know that the lifespan of the turbines is 20 years, according to DTE submittals to the Public Service Commission. I heard the young lady from Invenergy claim a 20-year lifespan as well. In Argyle, I believe that's consistent with the truth. Now, property values. If any of you seen the Holmes study in your townships from any of the wind developers, they love it. I saw it first in 2008. They say, see, no harm to property values according to the Berkeley National Lab. Well, let's listen to what Mr. Hone had to say about his own study. You can listen to the phone interview. He says, I think one of the things that often happens is that wind developers put our report forward and say, look, property values aren't affected. And that's not what we would say specifically. On the other hand, they have little ground to stand on if they say we won't guarantee that. Most wind developers have no interest in offering a property value guarantee, even though, according to their own premise, they'd never be at any risk of having to pay out on that guarantee, because their position is there's no harm to property values. The industry-funded studies all claim to show no loss. But there's a whole bunch of independent studies that show anywhere from 14 or 15 to 59% loss, including that obviously Koch brother funded group, the, where's it at? The London School of Economics. I mean, obviously the fossil fuel industry has deep, deep pockets. So now about this claim of exclusionary. You'll hear them say if you write strong language, it's exclusionary. They scream that at us in our township meetings. We're going to sue you if you write exclusionary zoning. They brought lawyers in from Colorado Springs, from Farmington Hills, from Grand Rapids, say we're going to sue you. Well, we can't exclude any lawful land use unless there's no appropriate location in that area to provide for the use. I would argue that appropriate location is defined by evaluating health, safety, and welfare impacts. The Michigan Bar has some statements on exclusionary, and they say, thus, an ordinance can arguably survive an exclusionary zoning challenge even when it undeniably prohibits a use if the use exists in nearby municipalities. Maybe you say, well, you know, Oliver Township has a lot of room for them over here. We decided that's a good place for turbines. It's up to you. Many Michigan counties and townships have adopted regulations that protect their residents from irresponsible wind energy development. It only took 2 turbines in Mackinac City for Emmett County to adopt a 36 decibel noise limit, and no more turbines have been constructed there. Mason County had only 56 turbines. That was enough for them to write an ordinance that stopped any more development there. Township after township after township after township has adopted strong regulations after investigating and exploring the facts. They have never been sued, with only one exception. Schoolcraft County got sued by Heritage Sustainable for adopting like a 3,900-foot setback and a 35 decibel noise limit. Just last month, the judge threw the case out, said it's not even right. You haven't applied for anything. You don't even have legal standing to be here. If they could sue their way into your township, they wouldn't negotiate with you. So most land use changes are pretty benign. Minimum lot sizes, sign ordinances, etc. Due to their size, wind turbines' impacts are disproportionately large. I felt that the change of land use was so massive and the impact so profound they should not occur without the consent of all impacted parties. We felt the 2-stage setbacks with a waiver option for noise and distance required the developer to negotiate with all the impacted citizens instead of just checkerboarding and ignoring the small land users who actually live there. I mean, when we looked at our wind leases, maybe 30 or 40% of the people that leased their farms didn't even live in the township. Remember, nobody's ever come to your planning commission and said, the light coming through my windows is too steady, could you make it flicker? The nighttime noise level is too quiet, could you raise it to 55 from 25? My property values are too stable, could you build some 50-story industrial machines next door to put that value at risk? Nobody's ever come in and asked for that. In fact, you wrote zoning to make sure those things wouldn't happen. The bottom line is with zoning, you were here first. You get to decide. Township zoning referenda have been performed, I don't know, a dozen, 13, 14 times. In my township, the developers hired ASGK Strategies, David Axelrod's firm, Truscott Rossman, Kelly Rossman out of Lansing. They poured thousands and thousands of dollars of billboards and everything else into our township. And the people approved the strong zoning for wind, 64 to 36%. We know in Moore Township, it was roughly a 3-to-2 ratio. Paris Township, Lake Township, Palmyra Township, Fairfield Township, or Seneca Township. I mean, the list rolls on and on and on. The bottom line is when wind gets put to the ballot of the local people, so far, wind has never won, no matter how much money was spent. So it's up to you. You get to decide. We don't know how Wheatland and our guide townships are going to come out, and I'm not going to tell you which way to vote, because I'm not here as an advocate for the election. But I can tell you that if you're wondering what do the majority of the people in your township think about this, so far we've never found a majority of the people in any township in the state to say yes. Wind developers ask communities to adopt zoning language that essentially awards free safety and easements across non-participating properties, in other words, trespass zoning. Reasonable wind zoning demands that those easements be negotiated individually and privately between the developer and the impacted landowners rather than forced upon them by zoning regulation. This we call property rights zoning. Who decides? The wind developers wants your 5 planning board members to make this decision for the entire township. With the 2-stage setbacks, each individual can negotiate the value of their own home individually, and the wind developer would have to compensate you. Unfortunately, despite the fact that they say we want to pour all this money into the community, once you raise the bar to the point that they have to compensate everybody who's going to be affected, they don't really want to invest that much money in your community because they leave. So I'll take 2 questions. Anyone? Yes, sir. Riga Township in Lenawee County. Riga Township in Lenawee County. I'm down on the state line. There were 5 townships where they wanted to build wind there. Yes, sir.
What is the difference between 45 and 55? My opinion is double.
You mean the perceived sound level?
Well, it's kind of like arithmetic. It goes up.
Well, it is logarithmic, but yes, and generally every 10 dB gain, Rick will correct me if I'm wrong, is perceived to be roughly twice as loud as the 10 below.
So would 55 be 4 times as loud as 35?
You double for the first one and then double up for 4 times.
Yes, 4 times. Yes, Rita?
I don't have a question, but if there's anybody here from any other township, I'm from Main Township, in Huron County. Our township voted it down. Don't let anybody tell you that with this lady and what I've experienced, what you can't hear will be a lot worse than what you can hear. I went myself and set, turned the car engine off, set my one. Oh, these are kind of cool. I drove around taking pictures of them. I thought they were beautiful. They still are. But, you know, tarantulas and poisonous snakes are beautiful, because I love animals. But I don't want it in my house. The shadow flicker was the most obvious, dumbest thing that I noticed. And then later I noticed there were things like what she's saying, my hands shake, I've had heart monitors, all this garbage going to the doctor. There's nothing wrong. It's stress. And I can feel it. And my husband thought I was nuts the first summer. I spent a whole summer thinking I was going insane. If you don't think that's fun, I mean, really, you've got to think about this. And this is for everybody. I don't know. So I get upset. That's why I was late, because I don't like this. I just want to live my life and be happy. And these people made it hell. Detroit Edison told me, yeah, we'll take care of the flicker. And you know what? They did. They turned it off on certain days, hours, whatever. And then I said, well, you know, now that it's been a year and a half, I got some bigger issues than that with it. And the guy told me, I told him what the issues were. He says, well, I won't be able to help you with that. And I said, why not? And his words, and I quote, because I would have to shut it down. They know damn well what they're doing to your health and your body, and they don't give a rat's ass.
All right. One in the back.
I'm surprised that Indiana is here because they won't let me come to their meetings, so I'm surprised.
Okay, well, we won't go any farther down that road. One final statement, and then we're going to have Zach come up and speak briefly. He lives with the turbines in Minden City. You've been very patient. If you want to slip one at a time and grab a little snack, nobody's going to be offended. Remember this, if you remember nothing else. Everything the wind developers are doing in your community is designed to do one thing: to give this property to them for free, with no consent, and without their compensation. They want the ability to trespass with noise and flicker and safety perimeters for free. Trespass zoning. Good neighbors don't demand that to make their project move forward, period. Thank you.